Join us in the fight to restore liberty and American exceptionalism. Together, let's make the case that our charters of freedom are worth defending and honoring. Right here is where the great American experiment comes alive. Let's get to work.
Okay, we're moving on to our last question here about Miranda warnings. And affirmative argument will be given by Mr. Krauser. And the question is, should the Miranda rights law be viewed as a distortion of the Fifth Amendment? Shane Krauser has the affirmative, and you have the negative cross.
I am opposed to the Miranda requirements, not because it's bad policy. In fact, I think it is good policy. I'm opposed to it on constitutional grounds. Here's what the Fifth Amendment says. No person shall be compelled in any criminal case to be a witness against himself. In 1966, the Miranda Court, the U.S. Supreme Court, said what? Well, you have a right not to incriminate yourself, and you know what? We've been going 200 years in this direction, and we're kind of concerned about law enforcement. So what we're going to do is we're going to make law enforcement advise an individual that he has a right to remain silent. He has a right not to speak. He has a right to the assistance of counsel prior to law enforcement interrogating the suspect. Again, I think it's good policy, but I'm not here to talk about policy. I'm here to talk about what the Constitution requires. The text of the Fifth Amendment is rather clear. If we are interpreting the Constitution, how did we manage to manufacture the liberty to be informed of one's right to remain silent? Consider this. If you believe in the idea of popular sovereignty, what it is that you ultimately buy into is this, that the power to govern begins with the people, that our liberties begin with us. Government doesn't give us anything. And essentially what the Miranda Court has done is this. We recognize that as a people, we are so dumb, we are so forgetful, that the very entity that we're going to give power to govern over us is also going to remind us what our liberties are. See, what we're seeing through the Miranda Court is nothing other than what we've seen go on for the last 100 years, and that is the government educating us, the government telling us what our liberties are, the government outlining how we're going to live our lives, cradle to grave security. That's ultimately what it's come down to. And the Supreme Court comes down with this idea that is nowhere supported in the Fifth Amendment of the Constitution. There's nowhere in the Constitution where you are told that where we've given power to the government to remind us what our liberties are. I mean, do we suggest that government is somehow going to remind us that we have the freedom of speech, that we have the freedom of assembly, that we have the free exercise of religion, that we have the right to be left alone, that we have the right to travel, to pursue an education, or refuse consent? Of course not. So why is it any different when it comes to our Fifth Amendment right to remain silent? This is simply a culture that has become one that is rather ignorant. And again, looking at the text, while there may be good policies, the text of the Fifth Amendment does not support the implementation of the Miranda requirements. As guaranteed by the Fifth Amendment, what is it saying? It says that you may not be coerced. You may not be made promises of leniency. None of those things can happen. You can't deprive an individual of food and water if you want to get a statement from him. You can't make him promises that if he does talk, you know what, we'll make it a little bit easier for you. There's certain things that can't be done. You know, depriving that individual of sleep, bringing in the garden hoses. That was the law for 200 years in America, and it worked incredibly effectively. It worked effectively. The burden is on the government to show that the confession was in fact voluntary. And in fact, they can't show that it was voluntary. The confession is ultimately dismissed. But to suggest that government must remind the citizenry as to what their liberties are is an affront to the Constitution, it's an affront to popular sovereignty, and it's an affront to this idea that the power to govern begins with us.
Thank you. Mr. Weisser, you have 1 minute to take a cross-examination.
So, to understand, Mr. Krauser, are you saying that the history of American jurisprudence, including Southern courts, have always respected the rights of the accused?
I wouldn't agree with that.
Would you say that because of the angels that human beings tend to be, we really didn't actually need the 4th, 5th, 6th, or 8th Amendments to protect the rights of the accused.
No, those are critical.
So, one last question. Do you assert that all people have an equal and perfect understanding of their rights in all cases?
No.
Those are the questions I had asked.
Okay. We'll move on then to the negative argument, 5 minutes. Mr. Weisser.
I want to clarify something that Mr. Krauser, I know, is aware of, and that's that the Miranda case started in Arizona, and in the end, after a second trial, Miranda was found guilty. He was kidnapping and rape, I believe, were the actual causes, and after serving time in prison, this bad individual was later knifed to death in a bar fight. I want to start there to be sure that earlier when we were talking about heinous individuals, that the legacy of Miranda is actually based on, in fact, a heinous individual. If there was somebody who could justly probably have earned our revenge and we could skip due process, he might have been one of the people that would qualify. But those exceptions for our sense of revenge, for our quest for swift justice, aren't what America is about. Now, Mr. Krauser talked about the 5th Amendment, which is essential to the rights of the accused, and in fact, it says that an individual cannot be compelled in the criminal case to be a witness against himself, nor deprived of life, liberty, and property without due process of law. And then in the 6th Amendment, it goes on to add that the person needs to be informed of the nature and the cause of their accusation. They need to have an opportunity to confront witnesses against them and have their own ability to compel witnesses to testify for them. So these are all protections for the accused. And sure, when it comes to heinous individuals in the egregious cases, we want to have firm, swift justice. But I wonder, out there in this audience, and maybe Mr. Krauser, have you ever been unjustly accused of a crime? When it comes to being unjustly accused of a crime, the power of government is terrible to behold. We're at a situation now where if an officer disagrees with your interpretation of how you respond to his question, he can tase you and drop you to the ground. We see this happen again and again. We see abuses of law enforcement again and again. Earlier I referred to mistakes that can be made. Overzealousness, over-aggression is what we want protection from. I look at the older individuals here in society, or here in the audience. Last week we saw an older individual in Texas confronted by the police, didn't know how to react, and so they shot her to death. Were the laws designed to protect that woman? Actually, I think they are. And that's why we have things like Miranda. If you don't happen to speak the language in the United States, if you don't speak English, then you're at that same disadvantage as the people staring at the bottom of the staircase wishing there was a ramp. If you are flustered or afraid because of the power and the terror of law enforcement trying to subdue you, there's chances you could say all sorts of things that aren't exactly dealing with your case, but can be misinterpreted. I'm sure that all of you can think of times when you said something in a hurry that wasn't necessarily your admission of guilt of one issue, but were misconstrued. That's why we have to have a situation like Miranda. You cannot provide a person with counsel if they are so scared of the law enforcement that they don't even have the opportunity to ask for it. When you are being confronted by a force of power, it's difficult to think straight. Miranda is designed to protect all of us citizens, especially the rights of the falsely accused. I'm not going to tell you that Ernesto Miranda was a stellar person. History shows that he was not. But the rights that he initiated, which have been challenged in 2000 and then reaffirmed, are necessary to having a justice which has equal protection and secures due process.
Thank you, Mr. Weisser. Ms. Krauser, you have 1 minute. Affirmative question.
Mr. Weisser, do you believe that the government should have to remind the individual of liberties like freedom of speech?
In cases where they're being accused of a crime?
Just in general, freedom of speech?
I don't see that question is applicable to the circumstance.
Do you want to answer yes or no? Should the government ever have to advise an individual that they have a right to freedom of speech?
No, I do not wish to answer yes or no.
Freedom of assembly?
Again, you're talking about
Yes or no?
privileges, not immunity.
Quit filibustering, Mr. Weisser. I've answered your questions. I'm asking to just simply give me a yes or no.
I'm going to say you're not asking a question that applies to this context.
So this is my cross-examination. Would you stand behind mandating that government advise the individual that they have the freedom to assemble?
I stand behind making clear the rights that we have and our immunities as well.
Free exercise of religion?
Yes.
The right to defend themselves?
Yes.
So you think that the government should have to advise the individual that they have the freedom to exercise their religion and to defend themselves?
I believe that the function of our government is to continuously remind the individuals of their rights and immunities. Yes.
I don't think, very good, that's all of my cross-examination.
Okay, that's time. Affirmative rebuttal, this will be 5 minutes, Mr. Krauser.
I don't think Mr. Weisser, quite frankly, knows what he believes on this particular issue, to be quite frank. To suggest that government has to remind us of our liberties turns the American experiment on its head. That's simply absurd. To say that government under some circumstances should have to remind the individual that they have the freedom to exercise their religion or the freedom to defend themselves, how absurd is this? That the idea that freedoms are inherent in the individual, that we're endowed by our Creator, yet we are so inept and ignorant that government should have to remind us what those liberties are. Prepare to be enslaved. Once we've come to that point where we say we are going to give the government the mandate that they tell us what our rights are. Here's the interesting thing about Miranda. Why is it that the individual doesn't have to be informed of his right not to consent to a search? If an individual is pulled over by the police and they're asked, and you are asked, for example, can I search your car? Why is it that government doesn't have to remind you that you have a right not to consent? There's an inconsistency. The court has made very clear, if we want to talk about the U.S. Supreme Court, that the individual does not have a right to be informed that they don't have to consent. We've created this very interesting exception with Miranda, that he has a right to be told that he has a right not to speak. Yet we talk about corruption at the same time. How is it that you can, at the one hand, say we have a corrupt government where law enforcement officers lie, they're overbearing, they're dishonest, yet a few magical words are suddenly going to change that? How does that work? Where these corrupt, overbearing, over-the-top police officers are going to read these few magical words and that's going to change everything. The fact of the matter is that individuals should be informed. See, we put this idea on the backs of the government, and as a result, we are less free in 2014. Why? Because it's government's job to take care of us. It's cradle-to-grave security, up to and including informing us when we don't have to talk. That is an obligation of the citizenry. And we know it's an obligation of the citizenry from the perspective of the founders because they made it clear in the Constitution itself. They were the ones who made it clear that government cannot coerce the individual. But there is nothing in the text of the Constitution, absolutely nothing, that government has the obligation to inform the individual of any given liberty. It simply does not happen, with one exception, the Sixth Amendment, where the individual has a right to be put on notice as to the accusations being made against him. That's the only time where government is mandated to inform the individual that that government is now mounting their resources against the individual. Paul Cassell is a professor at the University of Utah. He claims that as many as 28,000 criminals walk every year as a result of Miranda mishaps by law enforcement, and that confession rates have decreased since the Miranda Court's decision. Another professor at University of Michigan Law School, Professor Yale Camisar, argues that those numbers are trumped up. Who knows who's right? We've been talking a little bit of policy here and there. I want to move away from policy and say, what does the document say? If you believe that, in fact, individuals should be apprised of those liberties, and you didn't have a U.S. Supreme Court, would we really as a nation move to amend the Constitution to protect that specific liberty, that civil liberty? I think not. I think not. I think this is a Supreme Court that was being disingenuous, and they were playing judicial gymnastics with the Constitution that's been distorted in so many ways.
A negative rebuttal, Mr. Weisser, you have 4 minutes.
Well, one of the key things that Mr. Krauser talked about, and I really appreciate, is the concept of equal protection. Equal protection happens when people are on a level playing field. Now, I agree that it's a shame that not everybody knows their government. That's why I spent 12 years teaching U.S. government history, to make sure that the individuals stood up and learned at least the basics of what we expect out of our citizenry. America is a government of and for and by the people, and needs to have active and informed citizens. That's why we have compulsory education, which is not part of the Constitution directly in this case. That's not what I'm arguing here. What I'm arguing is, unfortunately, we don't have equality of information in America. We all know people who don't speak the language, people who have mental illnesses or are facing disabilities and are not functioning at full awareness of their constitutional rights or even of their faculties. Now, the history of American jurisprudence shows us that the Southern courts consistently acted unjustly, taking advantage of the individuals. In fact, Mr. Krauser points out the John Bingham and the establishment of the 14th Amendment, which was, in part, established to protect the citizens against abuses that were going on at state-level governments, to make sure that all citizens had equal protection if you were a member of the United States. In fact, it goes on to specify that all people, whether you're a citizen or not, get equal protection. Now, people who aren't necessarily citizens aren't necessarily versed in English and may not necessarily have the expertise that we would expect out of an adult. So I do not see a sense of equal protection if we expect them to have that knowledge. Further, a child doesn't necessarily have the same discernment and wisdom as an adult, and so we need to have additional protections for them. Now, according to the procedure, when you take someone into custody, it is in fact coercive. Once somebody is in custodial interrogation, their rights are shifted, and they're not necessarily giving of their information voluntarily. The mere fact that they're in custody is changing the dynamic of the interrogation. To say that these people, all Americans, do not deserve the protection of knowing what's going on, why it's going on, seems like an injustice to me. Now, again, I ask the people in the audience, hopefully none of you ever have been unjustly accused of a crime. Hopefully, none of you ever have had a police light in your face while you're standing on the side of the road trying to remember what your name is when the cop says, license and registration. But if that happens to you, you need to know that our government creates protections for you against the abuse of power. The mere fact we have a 4th, 5th, 6th, and 8th Amendment shows that abuses of power are potential, so great of a potential, we have to have protections against it, informing the public of their rights at the time, the most important time of their life when it comes to being accused, is certainly central to the concept of equal protection provided by the United States Constitution.
Thank you very much. Okay, now we have closing statements in reverse order that we had opening. So, Mr. Krauser, you have 3 minutes.
Very good, thank you. What we've heard, I think, consistently across the board on all issues is simply this: the sound of fury signifying nothing. We've talked policy, 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 and we continue to avoid, at least Mr. Weisser seems to have avoided over and over and over again, the very text of the Constitution. From affirmative action to abortion, to the death penalty, and now ultimately Miranda. What does the document say? That's the contest that we're engaging in tonight. And it was John Philbot Coran who said, "It is the common fate of the indolent to watch their liberties be made prey by the active." It's the common fate of the indolent to have our liberties made prey by the active, the lazy. That's what happens to a lazy people. What we've had here tonight is 4 issues. And each one of the issues that I've outlined coincides not only with the text of the Constitution, but with the historical underpinnings. That is, what the founders had to say about each one of these issues. And if we're going to talk about original intent and original understanding, those are the questions we have to answer. Not whether it's a good idea or a bad idea in 2014. We have to ask, are these based on good, sound principles? Those are the ideas that we're trying to implement. Affirmative action. In no uncertain terms, the 14th Amendment says equal protection under the law. We're talking about equality of opportunity, not the equality of results that Mr. Weisser continues to advocate for. The death penalty, unequivocally, in the 5th Amendment, twice, it's made very clear that under certain circumstances, life can be taken. When there's a capital offense, the founders preserved this idea of a grand jury indictment before the government moved forward. It also says that when life is taken, or prior to life being taken, due process must be satisfied. It's again reiterated in the 14th Amendment. Every single colony, every single state in 1788 had the death penalty as a part of their penal system. Abortion. The Declaration of Independence makes this case rather clear. Endowed by our Creator with life. It's further solidified in the 5th and 14th Amendment. That is, life cannot be taken unless due process is satisfied. We're allowing one individual to make that decision as to what happens to that life. And finally, Miranda, the 5th Amendment. It ultimately protects against coercion. We want to talk about equal protection under the law? That's what we're talking about. The government may never coerce any individual to speak. A coercive environment exists at the time an individual is taken into custody. That's absurd. The 5th Amendment forbids a coercive environment in order to compel someone to speak. Under those circumstances, no one could ever speak because the 5th Amendment would always be violated. It's not a coercive environment. It's an environment where the government is mounting its resources, but the individual ultimately can decide whether they're going to speak or not. John Adams said it best: support liberty at all hazards is certainly under attack, and that's evident here tonight.
Thank you. Mr. Weisser, for 3 minutes.
Well, I'm going to go in reverse order, and I want to remind you that the Miranda decision reminds us that the Constitution protects the individual. The Constitution protects the individual because organizations have made mistakes. They've done the wrong thing when they were thinking they were doing the right thing, and they've done the wrong thing on purpose thinking they could get away with it. All citizens cannot have equal protection under the law if they're not presented with equal information about their accusation. Miranda reaffirms 4th, 5th, 6th, and 8th Amendment protections from abuse. Mr. Krauser may tell you that he is unaware of a concept called custodial interrogation, but there is a clear change in case law and in the situation itself when you go from being questioned to being arrested. And that is when we have the Miranda rights expressed. I know I beat that to death, but I wanted to get that kind of wrapped back. I also would like to assert that Miranda like affirmative action, is the equivalent to that ADA handicapped ramp out there. It doesn't force individuals that can walk up the stairs to walk up the stairs. It gives other people an opportunity. Now, there are some people who don't really want others to have an opportunity. They prefer to see the government as a weapon to hold the other at distance and use the power of authority to keep people from conflicting with their desires. But the fact is, if you do not have some sort of a protection for individuals of the abuse of power, there will be abuses of power. This is the reason that we have the Constitution in the first place. This is the reason that they then went back and added first 10 and then 17 more additions to this Constitution to make sure that we have a society that protects the individual, that creates equal opportunity and is of the people, by the people, for the people, instead of just using the law as an excuse for oppression.
Well, thank you very much. And that wraps up for today.
Thanks.
This is much more fun.
Yeah, absolutely.
Mr. Krauser and Mr. Weiser for being here.